Hello everyone, so welcome back to the English Law Channel. So I'm carrying on with Tort and looking at some of the suggestions for reform, because there was the Pearson Commission chaired by that distinguished judge, Lord Pearson of Rannoch, and they suggested several reforms in this area because they said that the cost of running the system is far too high, and that so there's a no-fault liability system there to compensate anyone who suffers accidents, and doing so on the basis of need, nothing to do with fault. And because New Zealand runs a scheme on those lines, started in 1974, and they got rid of a tort for personal injuries from accidents. So this state compensation scheme was founded, and employers, car owners, and the government, they all paid into it. And this allowed payments to be made out on an administrative basis without having to demonstrate fault on the part of any party. So the proposition for this reform to be replicated in the United Kingdom with a no-fault system hasn't been implemented so far, and the fault principle is still at the heart of tort law. There are some human rights principles to take into account, because the Human Rights Act 1998 was was passed then and took effect in 2000, thereby transposing the European Convention on Human Rights into domestic British law, meaning that United Kingdom courts could adjudicate on the basis of it. The cases didn't need to be sent to the European Court of Human Rights in Strasbourg for adjudication. So it's now unlawful for any public body to act in a manner which is incompatible with a convention right. But you notice there's a gap between that and being compatible. You might be not incompatible without actually being compatible with it. And courts are, of course, public bodies, as are many other things, but what counts as a public body is a time for another, is something I'll bring up in another video. Anyway, so how about human rights, negligence, and the role of public bodies? Well, so there is growing anxious solicitude about this. Some types of defendants in tort actions manage to avoid bearing the consequences of what they've done and what they failed to do, even though they have been reckless and they have wrought damage to other persons and their property. For the most part, these defendants have wide discretionary powers. These are the police and local bodies. Now, the police are, of course, entitled to damage people and their property in very particular circumstances, but they seem to be getting off scot-free. It's very hard to bring action against these bodies if the body in question has made a decision in a certain way and has carried out these duties in a slipshod manner. If the police officers arrest someone they suspect to be a dangerous felon, there's a decision to act. But carelessly doing so would permit the felon to continue to stay at large. They didn't apprehend him, and the criminal then goes to injure an innocent third party. So there are certain proofs that the public body will be held liable if certain proofs are evinced. But this is tricky because the public body might not act, and then where it's alleged that this failure led to the damage, that third party being injured. So failure to make the arrest, or even attempt the arrest. So we now have to look at this situation a different way. So the police fail to arrest a felon who is a real public danger, and because they said that there are other policing issues they have to handle, and these are higher priority. So they can't even start investigating this alleged felon. So the criminal then goes injures an innocent person. So in this later scenario, liability on the part of the police is very difficult to prove, even to the civil standard. Of course, tort is a civil law matter. So again, the courts are very hesitant about imposing liability on any defendant who's simply not acted. The Omissions Principle was upheld in Robinson against Chief Constable of West Yorkshire Police 2018, a case going all the way back to the Hillsborough disaster in 1989. So this reluctance to take action on the parts of the courts is because they think that would unduly tether public bodies, particularly the police, and the courts don't want to be directing their operations. The police and so on, they know how to police best. We just let them get on with it. Otherwise, the judge becomes the chief constable. So they don't want to make it just impossible for the police to carry out their duties. There are so many calls in their time, they cannot clear up every crime. They've got to prioritise. So the courts thought in this hypothetical scenario the police should have investigated the crime. The court would be controlling how the police chooses to prioritise these matters. In the Robinson case, the Supreme Court found that the absence of a duty in these cases doesn't depend on policy considerations. However, you can justify it on the ground of the general principle of negligence. So I'll look more at that theme later on. So over time, lots of courts have decided cases that have been brought before public bodies, and they consider two factors. The bodies enjoy a wide degree of immunity from tort actions. This immunity, this is quite a new thing, because it claims against education authorities saying that they haven't properly educated children, and therefore people have suffered economic losses later in life because of this miseducation they received, are seen to be beyond the ambit of tort. Now, you see, these immunities seem to be at odds with the idea that law has to be remedial if a wrong has been suffered. But this sort of wrong doesn't fit into any legal category. So rulings on the liability of public authorities now need to be understood on the basis of the Robinson decision. And the Supreme Court looked again at how the law developed in this area. So there's a few examples that I adumbrated here and before. And you can see lots of public defendants are being called to account, and they are charged with responsibilities that could impact the health, the well-being, and indeed the very lives of people. So that could lead to people losing their right to life. And of course, that's there in the European Convention on Human Rights. That's the sacred right. That's the right from which all the others flow. Your right to freedom of expression or freedom of association is no good if you're dead. You can't exercise any of those other rights. So you have to protect people against inhuman or degrading treatment and punishment. So what would be made of these claims in the legal system is a moot point. We've yet to see. These things have not really been put to the proof. So courts have to consider the human rights principles when they're judging any case. There's Campbell against MGN Limited. Here, Baroness Hale of Richmond in that case said, neither party to this appeal has challenged the basic principles which have emerged from the Court of Appeal in the wake of the Human Rights Act 1998. The 1998 Act does not create any new cause of action between private persons, but if there is a relevant cause of action applicable, as the court as a public authority must act compatibly with both parties' convention rights. The court's approach to these issues, which the applications raise, has been modified because under Section 6 of the 1998 Act, the court as a public authority is required to act in a way which is not incompatible with the convention right. Anyway, she goes on to talk about other cases against Ray S., a child identification restrictions on publication, 2004. She cites another case, Wainwright against Home Office, 2004, about an invasion of privacy when this woman was going to visit her husband in prison. Okay, so that's enough for the moment on these torts. Toodaloo.